Hello, everyone. Welcome to the 2021 Virtual Elder Law Day Summer Series. My name is Christy McKenzie. I am the Assistant Coordinator of Neighborhood Services for the Department of Senior Services with Erie County. This program will continue to run throughout the summer, every Tuesday and Wednesday, covering a variety of topics beginning at 10 a.m. I would also like to take a minute to thank those individuals who helped to make this summer series possible again this year, including our County Executive, Mark Polenkars, our Senior Services Commissioner, David Schenk, and Karen Nicholson, the CEO for the Center for Elder Law and Justice. This program is also being recorded. If you would like to ask a question, we ask that you refrain from entering any personal information in the Q&A box below. We'll be answering questions throughout the presentation. Please allow me to introduce our guest speaker, Jamie Smith. Jamie is a partner in the firm of Smith Vavonese. Jamie concentrates her practice in the areas of trust and estate planning, elder law, estate administration. Currently, Jamie serves on the board of directors for the Center for Elder Law and Justice and is a member of the State Analyst of Western New York. Welcome, Jamie.
Thank you. Good morning, everyone. So today we're going to talk about two very specific types of trusts. We're going to talk about Medicaid Asset Protection Trusts, which are also known as Irrevocable Trusts, and we're going to talk about Pooled Supplemental Needs Trusts. So we're going to start with the Medicaid Asset Protection Trust. And as an elder law attorney, the one question that I get most often when people come in to see me for the first time is, how do I pay for long-term care insurance? That is a concern of most people. And what I tell them is there's really three ways that you can pay for long-term care. If you're lucky enough to have long-term care insurance and you need care, you can certainly file a claim to have that start paying. The problem with long-term care insurance that I see is that if you don't have it and you're pricing it out, it can be very expensive. Typically, if you're a healthy 60 to 65-year-old person, I'm told that the premiums can go anywhere from about $5,000 to $7,000 a year, and that's per person. So if you're a married couple, that could be anywhere from $10,000 to $14,000 a year. That would be, again, for a comprehensive policy that would pay what it costs to pay in a nursing home today, which I'm sure some of you may be aware is anywhere between $11,000 on the low end a month and about $16,000 on the high end. The other issue that I see with long-term care insurance is that for clients who have purchased it in the past and they come in to review, they're complaining that their premiums have increased. And in some cases, are doubling. And should they pay that higher premium to keep their current coverage, or should they get rid of their inflation rider so that they can still pay the premium that they started to pay? A lot of people aren't aware or didn't understand when they purchased it that those premiums can increase, and sometimes that becomes cost prohibitive. For newer clients who are still looking at different options to pay for long-term care insurance, they sometimes have issues with medically qualifying for long-term care insurance. Even if, you're relatively in good health, but you may need a knee replacement in the future, you may take a certain medication that can also be used for, dementia or something else, the underwriters may not be willing to insure you. When I first started practicing, long-term care insurance was a big thing, and John Hancock and MetLife were selling all these policies, and they had unlimited benefits, a lot of partnership policies, which means once the benefit is exhausted, you could apply for Medicaid and have the state disregard your assets. Those policies are gone, unfortunately. MetLife, John Hancock, they're not selling long-term care insurance anymore. They are still servicing the policies that they did sell, but it became apparent very quickly that the insurance companies were losing money. So the other issue we see is that the coverage may not be sufficient. Some people will come in and say, I have long-term care insurance and it pays $3,000 a month towards the nursing home. Well, if the nursing home's $11,000, obviously that's not going to cover your stay. And then you're looking at using your assets or your income anyway to cover that shortfall. So the second way that we can pay for long-term care costs is to private pay. And this is obviously using your own assets and income. It's probably the least desirable of the three options because people have worked hard all their life saving assets and working, and you know, again, with the average nursing home costing between $120,000 to $180,000 a year, you could see how quickly your assets would be depleted. And then the third way is Medicaid. And not to get that confused with Medicare, because a lot of people do. Medicare is the health insurance that we're all entitled to when we turn 65. And that will pay a very limited benefit for nursing home care. And what that will cover is if you are admitted to a hospital for 3 days, and then you're discharged to a nursing home for rehab, Medicare will cover a maximum of 100 days for that rehab stay. Days 1 through 20, it covers 100%, and then days 21 through 100, it'll cover 80%. And that's assuming you're lucky enough to get 100 days, because typically what happens is when someone goes in for rehab after a couple of weeks, if the therapist determines that, you know, Jane has plateaued, she's really not improving, and, you know, they're going to cut her off at that time because they're afraid Medicare is not going to reimburse them. Or if Bob has cognitive issues and he's not able to take direction from the physical therapist, he's not participating, you know, they'll cut him off at that time. But if Jane needs 2 people to help her with all her activities of daily living, like transferring from the bed to the chair, or she needs assistance with eating or bathing or walking, they're going to say, but you can't go home, Jane, because it's not safe for you to go home without having 2 people help you with all those activities of daily living. Or Bob, you need someone to supervise you 24 hours, 7 days a week. And if there's no spouse at home, or even if there is, that spouse typically can't be the only caregiver for somebody who needs 24-hour care with a cognitive issue. So when that occurs, they transition you from the rehab side of the facility to the long-term care side. And that's what we think of as a nursing home traditionally. And Medicare does not pay for long-term care nursing home. So that's where Medicaid comes into play. So Medicaid is the government program that pays for nursing home care long-term. But in order to qualify for Medicaid, you have to be at or below certain asset and income levels to qualify. And there is what we call a look-back period for nursing home Medicaid, and that is 5 years. So that means when you go into the nursing home and you apply for Medicaid, the Department of Social Services, which is the agency that administers the Medicaid program, will say, okay, if you want us to pay, you know, $10,000, $11,000 a month to the nursing home, we need you to provide us with all of your statements from your bank accounts, your IRAs, any property that you own or sold in the last 5 years. And like forensic accountants, that caseworker is going to go through all those statements and they're going to see, did you give away money within that time frame? Not only like, here's a check to a child, but did you pay for a child's, you know, divorce, their legal fees for their divorce, or did you pay tuition costs for a grandchild? And to the extent they see that you made gifts within that look back period, they're going to add them all up and they're going to impose a sanction. And for a certain number of months, depending on how much money you gave away, they're going to say, well, Medicaid's not going to pay the nursing home for this period of time. We don't care who does, but it's not going to be Medicaid. So how do we qualify for Medicaid? What are the resource allowances that we have to be spent down to in order to apply for that program? And we're going to talk about not only nursing home Medicaid, but we're also going to talk about community Medicaid waiver programs. Those are programs where people who are living at home can apply for home care and social day care and therapy services, etc., and have Medicaid pay for that care for them to remain at home. So for a married couple, if there's a spouse living at home in the community or in an apartment, that spouse is allowed to keep a minimum of $74,820 in non-exempt or countable assets up to $130,380. So that's pretty generous. The institutionalized spouse who's in the nursing home can only keep 15,900 in, again, non-exempt assets. So then what are the exempt assets? The primary residence is exempt. So if we have a spouse living in the house, we're not going to count that as part of that 74,000. That's in addition to it. And in New York, the value of that house could be up to $906,000, which is pretty generous as well. But keep in mind that, you know, in Western New York, that would be a very nice house. In New York City, it would probably be a, you know, a co-op apartment or something. Retirement accounts of any value, and I highlighted that, are exempt if they're in payout status. So that means when we turn 72 now, we have to start taking distributions from our retirement accounts. The government wants to start collecting the income tax on those accounts. So once that occurs, they can't count the value of that IRA or 401k or deferred comp plan as an asset. They would never make you liquidate that account and use it to pay the nursing home before Medicaid would pay. So that's unique to New York, and that's huge because a lot of clients have the bulk of their wealth in retirement accounts. I have clients who have, you know, $1 million, $2 million in their IRAs, and they're on Medicaid because they can't count that account as an asset. The other exemptions include a vehicle, if there's a spouse residing at home, and again, that's an unlimited value as well. So you could be driving around a Rolls Royce, that's not a problem. Life insurance, if it's term and it has no cash value, they don't count that. If it's whole or universal, but it has a face value of $1,500 or less, they exempt that as well. If the face value is over $1,500, and most policies are, they look at the cash value and they count that as part of the 74,820 or 15,900 that the spouse and applicant can keep if they want to keep that as part of their non-exempt resource allowance. And then finally, any monies that are put into a prepaid irrevocable burial account are also considered exempt. So not just the plot. A lot of people have pre-purchased their plots, but we're talking about going to the funeral home and saying, you know, I want a traditional burial or I want a cremation, and kind of picking out everything you want, giving a check to the funeral director who does not cash it. That money goes into an interest-bearing escrow account until the person passes away, and that's exempt as well. So if I'm a single individual, and I need to apply for nursing home Medicaid or one of these Medicaid waiver programs, I'm only allowed to keep $15,900 in assets. So that could be cash in the bank, it could be stocks, etc. If I have retirement accounts, and again, they're in payout status, they're also exempt. And I should mention that if you're under 72 and you need care in a nursing home or at home, you can put those accounts into payout status without incurring any, you know, income tax ramifications in order to exempt them for Medicaid purposes. The life insurance, again, that we spoke about is also exempt. Now, if I'm living in the community and I want to apply for community Medicaid, my house is also exempt as long as I'm living in it. If I'm in the nursing home, it's not exempt if I'm a single individual. If I'm living in the community, I also get to keep a vehicle. Technically, a vehicle would be exempt if I'm in the nursing home if I needed it for medical transportation, but most residents in a nursing home see the doctor that's affiliated with that facility, so it's very rare that that's an exemption. And then certainly the prepaid burial account for the individual as well. So if I have excess resources above what we just talked about, and they're exposed, I know now, to pay for my long-term care costs, and I don't have long-term care insurance, and maybe I can't medically qualify for it, or I've priced it out and it's too much, then what we recommend to clients is that they consider a Medicaid asset protection trust if they want to be proactive and try to protect some of what they have that's exposed to nursing home costs or care at home costs. So the purpose of a Medicaid asset protection trust is to really start a 5-year clock ticking So that 5 years after those assets go into the trust, that those assets would be protected from having to be used to pay the nursing home if my spouse or I needed care. By doing that, you can also qualify potentially for those community Medicaid programs. Now, prior to October 1st of 2020, the advantage of those programs, not only that you get to stay at home and receive care, but the advantage was we didn't have a look back period. So I could conceivably divest myself of all of my excess resources by putting them into this trust, and then I could apply for community Medicaid the following month. And there wouldn't be a look back, which was terrific. With Governor Cuomo's Medicaid redesign team, they decided that one way that they're going to try to, shave the spending and the budget is they're going to implement a look back period for some of the community Medicaid programs. So as of October 1st of 2020, a 30-month look back period is supposed to be implemented for any transfers made on or after that date for some of those programs. But because of COVID and because of the funding from the federal government that New York State has received, they haven't implemented that look back yet. And they can't until the earliest would be January 1st of 2022. So there's still a lot of uncertainty about how these rules are going to be applied. We are hopeful that, even if this does get implemented in January, that if you are transferring assets prior to that time and you make an application for the home care community Medicaid, that you'll be grandfathered in, that it's not going to be applied retroactively, or that you're not going to have to, you won't receive a sanction on recertification, because once you are approved for Medicaid, you do have to recertify every year. Specifically, these transfer penalties are going to apply to what we call the managed long-term care program and the assisted living program. It's not going to apply to the nursing home transition and diversion waiver, which is a waiver program that's specific for people with cognitive issues like dementia and Alzheimer's. So that's good news.
Jamie, there is a question.
Yes.
What if the payout in IRA account is over the asset that you are allowed to keep? What happens to the money?
Can you repeat that? I didn't catch the first part of that. Sorry.
What if the payout in the IRA account is over the asset that you will be allowed to keep? What happens to the rest of the money?
So once the IRA is in payout status, they exempt it as an asset altogether. But the distribution that you have to take as part of the payout is budgeted as income. And there are income limitations to qualify for Medicaid too. Basically, if you're a married couple, the spouse who's residing in the community can keep $3,289.50 a month in income. The spouse who's in the nursing home can only keep $50. So if your income, excuse me, which includes that IRA distribution, exceeds those allowances, then you would have to pay that over to the nursing home first before Medicaid would pay the balance of your bill. So you could qualify for Medicaid with what we call an income contribution. So if your excess income is $2,000 a month, but the nursing home bill is $12,000, even if you have to pay $2,000 from your IRA or Social Security or pension to the nursing home, Medicaid is still paying the bulk of that bill, and it's still advantageous to apply instead of to pay that entire amount out of your assets. I hope that answered your question. Okay, so in terms of how do we set up this trust, who are the players, how does it work? So we have what's called grantors. Those are you, the clients who are setting it up and whose money or assets are going into the trust. And basically anyone who's over 18 can establish this type of trust. What you'll see when we get to the pooled trust section of the presentation is that you have to be disabled in order to set up a pooled trust. With this type of trust, There's no disability requirement. So I have clients who come in that are healthy, in their 50s and 60s and 70s who say, I want to set up this trust and put some assets in and protect these assets for my kids or, whomever, and that's fine. We don't have to say, well, did you have a stroke? Do you have Parkinson's? That doesn't matter. In addition to the grantors, a trust has trustees. So those are the individuals, or some people use corporate trustees like banks or other financial institutions, who are legally responsible for holding on to the assets that go into the trust. They're responsible for investing and reinvesting the money, and then making distributions to the beneficiaries, depending on what the terms of the trust tell them to do. And then we have the trust beneficiaries. So these can be, again, individuals like children, or the client can even receive income from the trust. It could be charities, and we can have lifetime beneficiaries, meaning if we want to be able to give money from the trust during our lifetime to our children or charities, we can say that in the agreement. And then we can have residuary beneficiaries, meaning when we're gone, when the grantors pass away, here's who we want these assets to be distributed to. Okay, so typically with a Medicaid asset protection trust, during the grantor's lifetime, the income can either be paid to the grantor from the investments that go into the trust. So if I have stocks that I put into my trust and I'm getting dividends on those stocks, and I usually take those dividends and live off of them, I can continue to do that once they go into the trust. If, however, I don't need the income from those investments that I'm putting into the trust because my Social Security, my pension, etc., is more than enough to cover my monthly and annual expenses, I can just reinvest or accumulate that income and grow that trust principal. Again, as I mentioned earlier, if I wanted to be able to make gifts to my children or my grandchildren during, my lifetime, I can name them as beneficiaries on my trust, and it's fine for my trustee to give money to them. The way that the trust assets are considered unavailable to pay for my nursing home care, however, is that I don't have direct access to that principal. So it can be paid to third parties, but not to me, because if it could be paid to me, then the county would say, well, then use it to pay for your care, which is what I'm trying to avoid. That being said, a lot of clients will put their house into this type of trust. And the terms of the trust do allow the grantor to have life use and to have exclusive right to occupy that property. Typically, the grantor is also responsible to pay all the insurance and taxes and utilities, ordinary maintenance and upkeep of the property like they were doing prior to putting it into the trust. And they still get to keep their property tax exemptions because everyone is always concerned about that. So STAR doesn't go away because it goes into the trust. Veterans exemption does not go away. And then at the grantor's death, any money that remains in the trust would go to whomever they've named as beneficiaries, whether that's their kids or their grandkids. And sometimes clients will say, I don't want it to go outright to my children. I want it to be held in further trust for them. So this trust can establish trust at the grantor's death for their children or grandchildren until they're a certain age or, whatever they deem is appropriate. And the advantage of this trust is not only does it start that 5-year clock ticking for nursing home Medicaid, but it also avoids probate. So when we die, whatever assets are in that trust will go directly to those beneficiaries and not have to go through the court, to go through a will. Our beneficiaries won't have to deal with the surrogates court and with attorneys to help with that. They won't be paying legal fees and court filing fees, and a trust can really be distributed as soon as someone passes away. There's no requirement the property remain in there for any period of time like there is with an estate. An estate has to remain open for 7 months because that's the time frame that a creditor is allowed to file a claim, but with a trust, that's not the case. So if we can avoid probate, I always tell my clients that's in their best interest. Okay. So
we have a couple questions, Jamie.
Sure. Yep.
Are these the only 2 types of trust?
No. There are tons of trusts out there. They're all different and they're used for very specific reasons. But in my practice as an elder law attorney, these are two of the most popular and important trusts. So that's why we're focusing on those today.
Okay, and I think you may have just answered this, but can you sell the home as a Phenotrust?
Yes. So that's a question a lot of people ask. They say, okay, if I put my house in there now, and 5 years from now, or 2 years from now, or 10 years from now, I decide I want to downsize or I want to move to Florida or whatever, can the house be sold? And the answer is yes. The advantage of having your property in the trust. Now, when I started practicing, we did life estate deeds very frequently. That is a transaction where you convey the remainder interest in your property to your children and you retain life use of the property. That starts the 5-year clock ticking for Medicaid purposes, and it avoids probate as well, similar to the trust. But the disadvantage of the life estate deed is that if I were to sell that property before I passed away, then a portion of the proceeds from that sale would have to be paid to my children, who are the remainder beneficiaries, and a smaller portion would be paid to me as the life tenant, which is not the case when the property is sold by the trust. If the trust sells my property, 100% of the proceeds stay in the trust at the time of sale and can be used to purchase another property for me. Or if I move into a senior home or assisted living, the proceeds can be reinvested in the trust in, bank accounts or mutual funds or whatever. So I'm not paying over any of the proceeds from the sale of the house if the trust sells it, like I would with a life estate deed. And my kids aren't paying capital gains tax potentially on the sale of the house like they would if it was held in a life estate. And that's because it's a grantor trust for tax purposes. So I get to exclude, when my house is sold by my trust, if I'm a married couple, up to $500,000 in gain on the sale of that property, or if I'm a single individual, up to $250,000. If I had just conveyed the remainder interest to my kids and retained a life estate, and then I sell the property, my kids are going to pay capital gains tax on the remainder proceeds because it's not their primary residence if they don't live with me. So the trust is definitely the better vehicle to use to hold real property. And once that property is sold, again, a new property can be purchased in the name of the trust that the grantor can continue to reside in, or those proceeds can be reinvested. Okay.
And there's two more questions. How much money can you take out of a trust if you need the money to repair something like your roof?
Okay, so the terms of the trust, or the way that we draft it, indicate that the grantor is only responsible for ordinary maintenance and upkeep. So if there's a capital improvement that has to be made on that property, the trust can make those capital improvements. If there's other assets in the trust, bank accounts, mutual funds, whatever, the cost to make those capital improvements can come out of other assets in the trust and not out of, the grantor's personal bank account. It could be paid by the grantor, but if I set up a trust, I put my house in, and 3 years later, I want to pay for the roof out of my own bank account, then the county's going to consider that an additional gift that I've made to the trust because I don't legally own that property anymore. So it's always best, in my opinion, to have the trust pay for those capital improvements out of other assets in the trust so that we're not creating a new look back period when that improvement is made.
Okay, and then can IRAs be placed in the MAP account, MAP?
So no, IRAs are individually owned. And because they're already considered exempt assets, there's no reason to put them into the Medicaid Asset Protection Trust. They're already protected as soon as we start taking distributions. So that kind of leads to this slide. How do we fund the trust? What assets or what money should we put in there? So when I sit down with clients, I always tell them, you don't put all of your assets in here. The point of this is not to deprive you of having, a high quality of life and having money to do things in retirement that you've worked so hard for. The point of this is to say, how much money do I think realistically I'm probably not going to spend during my lifetime? And I would rather have that money go to my kids as opposed to a nursing home. So what we do is we take a look at what are the grantor's monthly expenses? How much are we spending on utilities and taxes and discretionary spending because we like to go on trips or out to dinner, etc. And then we compare that to what the grantor's monthly income is. So how much do we have coming in every month from Social Security, pension, IRA distributions, etc. And based upon that comparison, am I accumulating income every month because my income is greater than my expenses are? Or do I have a shortfall? Am I pulling from my assets to cover what my expenses are, less my income? And that's kind of the starting point to decide how much to put into the trust. And in terms of what types of assets can go in, pretty much any type of asset can go in, like, my house, or if I have another property in Florida, if I have stocks or US savings bonds, cash in the bank, mutual funds, even non-qualified annuities, which means annuities that are not IRAs. So just about anything can go into this trust except for retirement accounts. And that's because they have to be individually owned in order to keep the tax deferral for income tax purposes, and because they're already protected as an asset for Medicaid anyway. Okay, the other concern people have with this type of trust is they say, well, if it's really an irrevocable trust, can I make any changes to it once it's set up? Because, what if I have a falling out with one of my children? Or what if someone passes away before me or becomes disabled? And the answer is you can make changes to an irrevocable trust. We always include a provision which is called a limited power of appointment. And that gives the grantor the ability to change the beneficiaries. So if I retain a limited power of appointment, I can add people onto the trust who I want to get money out during my lifetime, or I can remove people. And I can do that with the residuary beneficiaries as well, who I ultimately want to receive it when I'm gone. Similar to a will, you can do that. You can amend the trust by exercising that power. In addition, the grantor can also retain the power to change the trustees. So we always recommend that typically a child or two children act as trustees. We never want the grantor to act as the trustee of the trust. And the reason for that is if the grantor is entitled to the income and then goes on Medicaid, we don't want the Department of Social Services to say, oh, well, they're manipulating how the assets are invested so that there's less income that has to be paid to them. Because remember, income may have to be paid to the nursing home or towards your home care first before Medicaid pays. So if I name my children as trustees, but then I have a falling out with one of them, I can always remove that child and I can put anyone else on as trustee that I want except for myself or my spouse. So it's flexible in that respect. And then finally, even though the trust is an irrevocable trust, under our New York Estates Powers and Trust Law, which is the acronym is EPTL, there is a provision, section 7-1.9, which says, if all the interested parties consent, an irrevocable trust can be partially revoked, meaning I need $50,000 for my trust back, or completely revoked. Let's say I set up this trust and 3 years after I do it, my husband has a stroke. We didn't make it to 5 years. Now we have to go to plan B, which is crisis planning. And that's a conversation for another day. But if that's the case, I can completely revoke the trust. Or if something in the law changes and I need to amend it, I can do that. I just can't unilaterally do that. I can't single-handedly revoke or amend my trust. I have to get the interested parties to sign off on it. And the interested parties are the beneficiaries and the grantors. So if I have my kids on there as beneficiary and I need to partially or completely revoke the trust, there's paperwork that gets prepared for all of us to sign. Once we all sign it, then the trust can be partially or completely revoked. So clients will say to me, okay, I like that, but what if one of my kids won't sign off on it? One of my kids as a beneficiary says, no, Dad, that's gonna that's my future inheritance. I'm not comfortable returning $50,000 from the trust. Well, you retain the ability to change the beneficiaries. So conceivably, you could remove that child as a beneficiary and you would no longer need that child's consent to do the revocation. So my point here is that there's a lot of misconception about these trusts being, completely set in stone once you set them up, and that's definitely not the case. There is flexibility. Okay, so clients will say, all right, well, what's the advantage of using this trust versus just giving my kids money or transferring assets into their name? So this slide kind of goes through the advantages and disadvantages of both of those two options. So if I set up a trust and put assets in, or if I just give, my kids money or property that I own, that will start the clock ticking to protect the assets. It starts the 5-year clock ticking and now the 30-month clock for home care. So that's good. The trust, however, protects the assets that I put in there from my beneficiaries' creditors. So if I'm concerned that, my child might get in a car accident and might get sued, if the person, didn't want to settle for what the insurance is worth, they could go after any assets that were in my child's name. If I just gave that child money from my bank account and said, hey, hang on to it informally for me, and if I need it, we have an informal arrangement, you'll give it back to me. Those creditors would never be able to get at the assets in the trust, even if your child was a beneficiary of the trust or is the trustee of the trust. So the trust does provide greater protection in that respect. Once I give money outright to my kids, they could spend it. Not to say that they would, but I really don't have any control over that. Whereas the assets in the trust, I can change the beneficiaries at any time. So if I have a falling out with one of my kids or, someone predeceases me, that money's not going wherever they want it to go. And that happens sometimes, people will give assets to their kids and then they predecease mom or dad. And that money might go to the beneficiaries in their will, which may not be the same people that mom and dad would want to receive it, or to their creditors if they had creditors of their estate, etc. I can change trustees. So we talked about that. So again, if one of my kids decides, I think this should be invested in stocks or bonds or whatever, and I don't agree with that, I can remove them as trustee. Whereas I don't really have a say in what my kids are doing with that money, legally at least. When it goes in their name, they can invest it however they want or spend it. The other big issue with an outright gift is tax consequences. So if I were to just transfer some stock that I own or real property to my child, and I have a low cost basis in that stock or that property, let's say I bought it some Ford stock for $20 a share and now it's worth $60 a share, my children or my beneficiaries are going to take those assets subject to my cost basis if I just gift it outright to them. So when they sell it later on, they're going to pay capital gains tax on the difference between what I paid for it and what it's worth at the time they sell it. With a trust, if those assets are still in the trust when I die and my kids receive those stocks or that property at the time of my death, they receive what's called a step up in cost basis, meaning whatever it's worth at the time I die becomes their basis. So if they then sell it, there's probably no capital gain or very little capital gain. So that's an advantage of the trust over outright gifts. From an income tax perspective, again, I mentioned we set up these Medicaid asset protection trusts as grantor trusts. And that means all of the income that's earned on the investments in the trust, again, going back to dividends, interest, rental income, if I put a rental property in there, that's all going to be taxed to me as the grantor and at my personal rates. And that's good because I never want the trust to pay tax. The trust tax rates are compressed And at about $13,000 in income, a trust would be in the highest tax bracket. So I always want to structure these trusts as a grantor trust so that even if the income is reinvested or it's paid to somebody else, I'm still claiming it on my income tax returns, just like I've always done, paying it at my rates. When we just gift money or assets to children, they have to claim that income tax on their own personal returns. And if I gave more than the annual exclusion amount, I may also have to file a gift tax return. Currently, that amount is $15,000 per person. It's not that you have to pay gift tax if you give more than that, but it's the filing requirement that becomes a pain in the butt. Whereas putting money into this trust, because I've retained the ability to change the beneficiaries, is considered an incomplete gift for gift tax purposes. So I never have to file a gift tax return by putting assets into my trust. So the trust is certainly the more costly option in terms of legal fees than an outright gift. It doesn't really cost anything to say to the bank, you know, move this money into a new account in my child's name, or to have your financial advisor do that. With real property, if you're going to transfer the deed, you're going to be paying an attorney to do that, but it's still going to be less costly than what it costs to set up a trust and have an attorney, you know, help you fund the trust. And certainly a trust is more complicated to implement and administer than an outright gift. There's a legal agreement, there's rules. You know, just giving money to your kids and saying, hang on to it in case I need it and give it back to me or whatever is going to be easier. But I think if we look at these two, you know, lists, I think the disadvantages of the trust are, you know, completely outweighed by the advantages. And I think a trust offers more protection and flexibility than an outright gift does to clients. Okay, so we're going to move on to pooled supplemental needs trusts. I probably could have talked another, you know, half an hour or longer about the Medicaid Asset Protection Trust, but we do have limited time, and I do want to spend some time on the pooled trust. So what is a pooled supplemental needs trust? This is a type of supplemental needs trust. We said there's lots of different types of trusts. Well, there's lots of different types of supplemental needs trusts. That's like a subcategory of trust. But basically, a supplemental needs trust is a special type of trust that is used to enhance the quality of life for people with disabilities. So we know that if we're disabled and we're receiving government benefits, that there are, like Medicaid or SSI, which is Social Security income or Social Security disability income, that there are limits as to how much money, assets we can keep, and income we can have. So this type of trust is a way to retain additional assets or income when we're disabled and have the funds in that trust pay for things that our government benefits don't pay for. And what's unique about a pooled supplemental needs trust is that it's a trust for many disabled beneficiaries who pool their assets or resources together for investment purposes. And typically a pooled supplemental needs trust is managed by a not-for-profit, and there's one master trust agreement, and the individual beneficiaries will sign what's called a joiner agreement saying, hey, I want to join the pooled trust and put my assets or income in there. So how do we become eligible to enroll in the pooled trust? Well, unlike the Medicaid Asset Protection Trust, we have to be disabled. And that's really in accordance with Social Security standards. Typically, we're receiving Medicaid benefits as well. I have had some clients who did not qualify for Social Security disability, either because they didn't work and have enough quarters or pay into the system to qualify, or maybe they're married, so they didn't qualify for SSI. So if you don't have a disability determination made by Social Security, you can always ask Medicaid for that disability determination as well. But Social Security disability or SSI is definitive proof of your disability. And for a pooled trust, if a person is over 65 years of age, there has to be a separate determination of disability made by the county if that person became disabled after 65. So if I, was a paraplegic or, had some other disability and was receiving Social Security disability or SSI, well, that's definitive proof. But at age 70, I'm diagnosed with Parkinson's or dementia. I never received SSD or SSI. So I have to prove to the trust that I am disabled. And Medicaid has what they call a Medicaid Utilization Review Board who can make that disability determination for me. And there's two forms that they require to be submitted in order to make that disability determination. One is a Department of Health, that's what DOH is, a one-page form that the primary physician has to complete. And then there is a 5-page disability questionnaire that the client or the family completes. And that paperwork gets submitted to the local Medicaid office, and that caseworker will send it to the Department of Health in Albany for that disability determination, which can take up to 60 days for them to decide. So why would I need a pooled trust? Well, we said if we're in receipt of government benefits, we know that there's income and resource limitations to qualify for those programs. So for Medicaid, if I'm a single individual, we talked about the fact that I can only keep $15,900 in non-exempt assets. And if I'm a single individual and I'm living in the community, I can only keep $900 a month in income. That's not a lot to live on. I don't even know if we could pay rent and utilities, probably not for $900 a month. And if I'm getting supplemental security income, which is SSI, I can only keep $2,000 a month in assets. So in order for me to remain at home, because that's where I want to be, I don't want to be in a nursing home, and to have a better quality of life, Congress said, we're going to allow people with disabilities to keep additional assets or income to pay for things that Medicaid and Social Security don't cover, so that they can achieve those results without completely losing all their assets or income or having to go into a facility. So within the pooled supplemental needs trust world, we have a first party trust. And that means the individual who's disabled is the one who's going to be setting it up. And they're going to use their own income or assets to put into the trust. And the first party trust is actually differentiated by your age. So if you're under 65, that's one trust. If you're over 65, that's a separate pool trust. And currently, we have no transfer penalties if you're in receipt of SSI and you're under 65 and you set up one of these trusts and put assets in. Not going to be sanctioned, not going to lose your SSI benefits. Because of the October 1st, 2020 implementation of the 30-month look back for community Medicaid waiver programs, it's unknown at this time whether a transfer penalty is going to apply if I use the pooled trust and I'm on one of those waiver programs. And that's very scary and very concerning. There are lobbying efforts by the New York State Bar Association, the Elder Law and Special Needs Committee to exempt people who use the pooled trust, who put assets in or income in, from being sanctioned, but there's no clarity on that yet. So we're keeping our fingers crossed. If I'm over 65 though, and I'm living in the community and I transfer assets or I transfer income into the pooled trust, and then I later need to go into a nursing home, I can be sanctioned because of that 5-year look back, unless all of the money I put in came back out to pay for things that will benefit me. The other thing to know about the first party pooled supplemental needs trust is that when I pass away, if I'm the beneficiary, it ends. No disbursements can be made after that time. Any monies that remain in that trust are going to stay in that trust, and they're going to be used to pay for other things that disabled beneficiaries who are part of that trust need at the discretion of the trustees. So the money in that trust doesn't go to my family, doesn't go to my estate, it stays there. So what type of assets or money would an individual deposit into the first party trust? So again, if I'm in receipt of Medicaid, I'm living at home, and let's say I have $2,000 a month in income coming in. I know I can only keep $900 to qualify for Medicaid. The Medicaid would say normally, well, $1,100 is your spend down amount. That's your excess income. So if you want us to pay all your medical bills, you have to give us $1,100, and then we'll cover all your Medicaid or all your medical bills. Or you show us that you've incurred $1,100 in medical expenses this month, and then we'll activate your Medicaid and pay the rest of the bills. So the pool trust is an alternative to having to give away that excess income to the county or to pay it towards medical bills. If I take that $1,100 and I put it into the trust, then I get to keep, in essence, all of my income. Because once it goes into the trust is going to say, what would you like us to pay for on your behalf? Can we help you pay your rent or your utilities or food or, a variety of other things, which we'll talk about in a minute. So the trust is used for people who have excess income and want to keep that income. The first party trust is also used when someone receives a direct inheritance. So let's say I get $50,000 from, my Aunt Sally's estate. She didn't realize I was receiving government benefits, or she just didn't do planning with her attorney to know that she shouldn't just give me money, but she did. So now I don't want to have to go off of Medicaid or SSI and spend this $50,000 down. I want to put that into the trust and have it be available to help supplement whatever it is I need for as long as it will last. So a lot of people who receive direct inheritances will set up the pool trust as well. Or if I became disabled and I applied for Social Security and I waited 2 years before I got a decision, and now I'm getting this retroactive award and I don't want to be kicked off of Medicaid, I can put that lump sum into the trust. Or if I was in some type of accident and now I'm receiving this personal injury settlement or structured settlement, I can add that to the pool trust as well. And then certainly you could use the pool trust to shelter excess resources. So if I'm disabled and I have too much money to qualify for Medicaid, I could set this up as opposed to doing the Medicaid Asset Protection Trust. But I say that with caution. That's typically not what we recommend, because if you have substantial resources in excess of what you can keep, and then you put this into the pool trust and you later go into a nursing home, you didn't make it the 5 years, that's going to be a huge sanction. This is not a trust that you can revoke like you can with a Medicaid Asset Protection Trust. So you got to be careful about that. We also have what's called a third party pooled supplemental needs trust. So this is established by a third party. So it could be a parent of a disabled child, as long as the child is over 21 years of age, because a parent has a duty to support a child under that age limit. Or it could be a friend or other family member of the disabled child or person who wants to leave money for them or give money to them without affecting their benefits. So instead of creating a private supplemental needs trust for that disabled beneficiary where, I'm going to an attorney, having the attorney draft the agreement, picking a trustee, if I say, I just want to add it to the pooled supplemental needs trust because there's going to be a corporate trustee, there's going to be continuity there. If, somebody passes away, there's always going to be a trustee to manage that money for them. They're going to know what the rules are concerning Medicaid and SSI and what's permissible to distribute to the beneficiary or to pay for the beneficiary. This is a good option for people who want to leave money without affecting a loved one's government benefits. And this could be set up during that third party's lifetime. I could say, you know, I have a disabled grandchild. I want to put $10,000 into the pooled trust to be able to have that money help them out now. Or I could say, I'm going to do this through my will or through a trust that I set up during my lifetime. And I could say when I die, you know, a percentage or a dollar amount goes to the pooled trust for that disabled beneficiary at that time. So with the pooled third-party trust, typically the not-for-profit has a after fund, which says when the disabled beneficiary passes away, a percentage of the assets in the trust remain in the pooled trust. Usually around, you know, 10 to 15%. And then whatever the remaining amount is, say 85% here, can be given away to whomever that third party designates initially when the trust is established. So if I'm setting up a trust for a disabled child and my child passes away and I still have, you know, $100,000 in that trust, I can say 85% of that is going to go to my other children or to my grandchildren or to a charity or wherever I want it to go. Only 15% remains in the pool trust. So in terms of what the trust can be used for, this really depends on what type of government benefits a person is receiving. So if a disabled person is receiving Medicaid only, perhaps they're on Social Security disability, they work, they paid into the system, they're not receiving SSI, the trust can really pay for just about anything. Rent, if they're renters, or a mortgage if they own a house, condo maintenance, insurance for the home or the apartment. It can also pay for repairs and maintenance on the property and taxes, utilities. So that would be gas and electric, water, phone and cable bills. If the disabled beneficiary wants to purchase new furniture for the house or the apartment, that's permissible. If they haven't prepaid their burial arrangements, the trust can pay for that. If they need groceries, they go to Wegmans, or if they want to go out to eat, or they want to go to a movie, the trust can pay for that. If they have a car and they can drive, or if they have somebody who drives for them, it can cover car payments for a new vehicle, insurance, and it can pay for anything that really the government benefits don't cover. So if Medicaid doesn't pay for depends or any other, you know, necessary medical or personal needs, it can cover that. It also can pay for the disabled beneficiary to travel and take vacations. So if you want to go to Disney, that's fine. They'll pay your airfare, they'll pay for your hotel, etc. And we talked about the transportation costs. If you're not able to drive yourself, if you want to take an Uber or a cab or whatever, that is permissible as well. Now, if a beneficiary is receiving supplemental security income, that is a benefit that's intended to cover shelter and food expenses exclusively. So because SSI is intended to pay for those two things, the trust really should not be used to cover food or shelter expenses, because that person could then lose their SSI benefits or at least have their benefits reduced by up to a third. So when someone is in receipt of supplemental security income, the trust really is limited to paying for vacations, furniture, any type of adaptive equipment, you know, maybe computer, transportation costs, gym memberships, education. So if they want to, you know, take some college courses or some training courses, they could do that. Car payments, any type of hobbies or sporting goods, their funeral expenses, and then non-food and shelter expenses. So telephone and cell phone bills are considered non-shelter expenses. So the trust can pay for that if the person's on SSI, as well as the cable and the internet. But those are really the only non-shelter expenses it should be paying for. Typically, the purchases have to receive prior authorization before the trust will pay for that item. We can't just say, I'm going to go out and buy this and I want to be reimbursed by the pool trust, because the trust is not supposed to or allowed to give cash to the beneficiary to reimburse. And if it's a big expense, like, you know, a new couch or TV, they can go to the store where they want to purchase it, get some estimates, have them send it over to the trust, and then once it's authorized, the trust will send payment directly to the vendor. The money never goes to the beneficiary to pay for those things. It's directly paid to those third-party vendors. There is a distribution request form that most trusts use that gets signed, and then it gets emailed, faxed to the trustees with the supporting documentation if we have estimates or invoices, etc. And the pool trust is not an employer, but they will pay for, you know, licensed home health care agencies, lawn care services, snow plowing, etc., but they have to be licensed. And again, if you're receiving Medicaid and you're getting home care services, they're not going to pay for those unless the county said, we're only going to approve you for 8 hours a day when you really need 12. They will pay for additional home care and services that you need, but they're not going to supplant what the government is already giving you, because the purpose of a pooled supplemental needs trust is to supplement what you're not receiving from government benefits. Was there a question, Christine, or we're running over time?
Yeah, there are actually a couple of questions that have come in, so I don't know if you want to answer them now or wait for your
Yeah,
notes.
that's fine. You can answer them now.
So can a whole life insurance policy that is valued at $250,000 be placed in a trust?
In a Medicaid asset protection trust, yes. You can change the ownership. You can change the ownership on that and the beneficiary to the trust, yes.
And sorry, I just lost the question. When a pool trust is established, can the individual apply for benefits like SNAP and cash assistance and renters vouchers?
So each government program has its own rules and regulations about how it treats supplemental needs trusts. The majority of them do allow you to apply for those benefits when you have a pooled trust. So we would have to look at each individual benefit to verify, but for the majority of them, yes, that's the point of the pooled trust, to qualify for those benefits.
And can you have both a pooled trust and a MAP trust at the same time?
You can. That's my last slide, actually. So I'm gonna wait till we get to that to talk about that. We're almost there.
And then we have one more. What happens if you are married in a pooled trust? Does the pooled trust go under one spouse? Does the trust money get dispersed to the surviving spouse? Many couples are asking, does the trust only go under one of the spouses or both?
Yes. So for a pooled trust, you have to have individual accounts if both spouses want to set up one. For the Medicaid Asset Protection Trust, that can be a joint trust. It doesn't have to be separate trust. But if you set up a pooled trust and you put, you know, income or assets in there, when the first spouse passes away, it stays there. It doesn't go to the surviving spouse. With a Medicaid Asset Protection Trust, the assets remain in there for the surviving spouse. So they're just very different types of trusts. I just want to briefly discuss what is prohibited in terms of disbursements from a supplemental needs trust. So again, I mentioned earlier, the trustees are never going to pay cash to the beneficiaries. That's not permissible because there's income limitations for Medicaid and SSI. And if they gave you cash, that would make you ineligible for those benefits. They're not going to pay for things for other people either. If you say, oh, I want to make a gift to my grandchild for his birthday, can you write a check? They're not going to do that. The point of the supplemental needs trust is for the sole benefit of the disabled beneficiary. Not the case for a Medicaid asset protection trust. We can use that to benefit grandchildren and other people. But with the pool trust, it's solely for your benefit. If you own a house and you have a pool trust, typically, the pool trust will not allow any money from your trust to go to make capital improvements to that property because it's not owned by you and it's going to benefit whoever is going to receive that property when you die. So that's not the case again with a Medicaid Asset Protection Trust. So again, they're very different. If you own a property, but you also rent a property, they're not going to pay rent and mortgage. It's going to be one or the other. Again, they're going to try to not pay for things covered by government benefits unless there's some reason it would be in your best interest to do that. Pool trust can't buy you beer or, wine or firearms, and it's not going to pay for any illegal activities. And it won't purchase a car to be owned by somebody else, because again, it has to be for your sole benefit. So for disabled beneficiaries who are interested in applying for the pool trust, the process is you apply for Medicaid, get a decision saying you're approved financially. You complete and submit the disability paperwork if that's necessary, meaning you're over 65 and you never received SSD or SSI prior to that age. And then again, there's an application and joinder agreement that you have to fill out, and you submit that with, proof of your income from Social Security or pension. If you're putting your excess income in, there should be a letter from Medicaid that details what that spend down is. And you submit all of that with that proof of disability, power of attorney if it's being signed by your agent or your guardian with that joinder agreement. And locally, we have a pool trust that's administered by People Incorporated and Center for Elder Law and Justice. That's called the Western New York Coalition Trust. I did provide the website. There's a ton of information on there. You can go on and check it out. But the local trust does require that you meet with an attorney and review all the documentation that has to be submitted before they'll approve you. Other pool trusts throughout New York do not require that, but the local pool trust is a great trust to use. I have hundreds of clients in it, and it's highly recommended. Okay, so back to the one question we had earlier about, can you use a pool trust with a Medicaid Asset Protection Trust? And the answer is yes. So I have clients who will come in and see me, and we set up this, Medicaid Asset Protection Trust to shelter their excess resources, to protect those for their children. And then they later need care at home. So we apply for community Medicaid, they start getting home care, but now they have excess income and they don't want to spend all that income on their medical care. They'd rather have that go into a pool trust to be used to pay for their utilities or their food, etc. So they can have the Medicaid Asset Protection Trust that was already set up for their assets. So, we can give money from that trust to their kids, and ultimately that will go to their kids when they die. And then they have the pool trust set up for their excess income so that they can keep all their income during their lifetime. So that is one situation where both of those trusts can be used together to protect assets and income from long-term care costs. And that concludes my presentation. So I don't know if there's any other questions.
No, thank you, Jamie. I don't see any other questions coming in. Thank you for that great comprehensive presentation. We learned a lot of information. I'd ask that the attendees who have joined today to please take a minute to fill out a brief survey that should pop up in a couple minutes. That will help us a lot. We appreciate it. And again, please join us next week, Tuesday and Wednesday at 10 a.m. for Knowing Your Rights, Entering a Skilled Nursing Facility for Short-Term Rehabilitation, and Asset Protection for Long-Term Care Expenses. Again, thank you, Jamie.
You're welcome. Take care, everyone. Bye-bye.
Bye.